I'm
Great.
Jennifer Welty. I'm our Vice President of Sales for Heritage Title Company. I'm filling in for Jill. Jill had a new little baby 3 weeks ago. So she's enjoying some baby time and hopefully some time away from work. If you need anything while Jill's out on maternity leave, please feel free to give me a call. My number is 303-847-2334, and I'll drop it into the chat. We're going to go ahead and kick it off, but if you have any questions, please put them in the question and answer box, not the comment box or chat box, and we'll get to those as we go. Damian will keep a good eye on it, as will I. But I wanted to introduce Pete Muccio. He's an attorney who specializes in landlord tenant law, incredibly knowledgeable, and has been staying on top of all the ongoing changes about tenant rights and landlord rights. It's important for brokers to be aware of the rules for landlords and tenants if they're listing properties that are rental properties, or if they're personally own any real estate as rentals. So if you have any questions, Pete is the guy to know.
Oh, Pete, It's good to have you here, guy.
Damian, it's great to be here, man. It's I feel like we do this almost every year, and I can't believe it's been a year, right? It's just time flies by.
Yeah, time flies when you're having fun, let me tell you. And you have a legislature that's crazy. But
yeah, well, it's I like to say I'm never bored, right? And which is always true, right? There's always something that's interesting that's going on, and this year there's been no shortage of that and of challenges and everything like that. So I mean, we got a lot of stuff to talk about, right? So let's just dive right in.
Let's jump in. Let's get going.
All right. Well, first, I've got the advisement, right? This presentation is for educational purposes only. So there you go. If these opinions are my opinions, and consult with your own attorney to determine what's the appropriate approach for you, right? But so let's talk about what happened this past year. If people haven't been paying attention, it was a fast and furious legislative session. And the main focus of the legislative session was, guess what? Property management, landlord tenant, that was it. I mean, there were multiple bills that were proposed that were impacting landlords. Some of them passed, some of them didn't. A lot of them passed. But yeah, it's just been absolutely wild. And the impact of these bills is significant as far as the operational impact for being a landlord. So if you are a landlord, if you know somebody that is a landlord, if you're managing properties, there's just a lot to be aware of, and a lot of pitfalls and a lot of changes that took place. I mean, I guess let's talk about some good news, though. Let's talk about some of the things that didn't pass. So this falls under the category of, hey, it could have been a lot worse. Right?
Jeez.
Yeah. So there's a couple of big ones. So there was the right of first refusal, which that was going to give municipalities the ability and the right to purchase certain multifamily properties. And the thing that I always question about this bill is, what's really stopping a municipality from going out and buying a property right now on the open market? Is there anything?
Not a thing.
Nada. They could go out and do it right now. So thankfully that did not pass. Another bill that was proposed that really got a lot of people's attention, and one we're probably going to see again, is rent control. Having rent control in place. Right now there isn't rent control in place, but that could have changed things. But that got shut down, so that was good.
Yeah, I think right now the municipalities are precluded from imposing rent control by virtue of, is it statute or constitution? Statute, yeah. So, which is great, but yeah, they want to undo the statute, and that's the talk.
Yep. Yeah, so that certainly could come back, and there are other places that have rent control in the U.S., right? New York City famously has rent control. How cheap is its rent in New York City, right? How good is that working out there? Yeah, not exactly the model for preserving affordable housing, in my opinion. So yeah, it's something that I'm sure we're going to see again. The other bill that was proposed that got shut down I know we're going to see again is something called a limit on the ability to non-renew somebody, right? So basically, a bill that would it's called just cause, and basically it would require you to have just cause in order to evict somebody. Well, that on its face sounds right? It's like, okay, well, you of course you want to have a basis, it's just cause in the name. What they really should call it is endless lease agreement, because that's what it actually is, because it eliminates or severely restricts the ability for a landlord to non-renew somebody at the end of their lease, and requires the landlord to offer up a new lease with significantly similar terms to the pre-existing lease. So as you can imagine, that could create a situation where you sign a lease with somebody, and it's like you're signing a lease with somebody, you're going to be together kind of forever ever type of situation, right? Unless there was a default under the lease agreement.
And it's important to point out that one didn't pass strictly because they ran out of time. They actually thought they had the votes and everything else, and that it was going to pass. But then the governor introduced that land use bill that took all the time, and it just got PI'd. I mean, just by accident, frankly.
Yeah, it's coming back. We're going to see it again. And I guess the thing is that the this is not a Colorado original concept, right? There are other areas. The state of Washington, some municipalities had it. Then it was expanded to the state level. New Jersey has had it since, I believe, the 70s. They've had a just cause bill. And Damian, I was going to look into the New Jersey law a little bit, and I was going to bring some more detail about that, but I said, forget about it. Just leave that.
Forget about it.
Forget about it.
So, Pete Muccio.
Yeah, there you go. So yeah, and the other part of that I think to be aware of too, and you're saying, why is this such a big deal? Well, there were cases where you could non-renew somebody, but you'd have to pay months of rent as a relocation fee to your tenant in order to get them to non-renew. And when you look at it, and when you hear about some of the things that we're talking about today, as far as the operational changes and the impacts that these laws have on running the business of being a landlord, you realize that the financial impact that could have on, what for many people is an opportunity to try and build wealth over time, is huge. And it really changes a lot of the factors and kind of makes you question, well, who's going to be a landlord if some of these things get passed? And, it's tough. And it's really important when you're looking at who gets voted into office, that you're looking at people that are going in that are moderates, right? And that have some business interests in mind and understanding of the economics of what it is to be a landlord and what that means. So, yeah, that's the good news. So let's talk about all some of the things that did pass, and we're going to go into the summary of those here. So here's the short version. So if you're just going to take away a couple slides here, this is it, right? This is the quick takeaway. There have been changes to the eviction demands, adding advisements of rights and affidavit requirements. For those of you that have been in the industry for a long time, you might be aware that a demand used to be on one page. Now those days are gone. Typically, eviction demands might be 2, maybe 3 pages, and you might have additional requirements to post depending on where you're located. For example, if you're dealing with a non-payment of rent situation in Denver, in addition to the demand itself, you're posting a packet of rights and resources to the tenant. But eviction demands across the state now have to have additional advisement language of additional rights. Advertising practices are going to change depending on what type of process you are going to adopt as far as screening. We're going to talk a little bit about that. That's going to also vary by applicant as far as the screening process, meaning, one of the golden rules as far as screening and how you treat people for years has been, look, you treat everybody the same that comes into the door through the screening process, right? That's really, really important. You want to make sure that you're treating everybody the same. Well, now with the new law that's gone into effect, it actually depends upon if that person has a voucher or not, because you have to screen somebody who is a subsidized tenant differently from somebody who is a conventional tenant. So it's just a huge shift in mentality and a huge operational shift for different people to deal with. Lease language. There was a whole bill that just says, hey, look, there's prohibited clauses limiting waivers of certain rights that might have been common in leases, limiting markups as far as fees provided by third-party vendors. Lots of changes to pet fees. That's actually going into effect in January. So a lot of changes to leases. And what does that mean? That means your lease has to get updated, right? And if you're yeah. So if you're a real estate
they just
broker,
were updated 2 years ago, right?
Exactly. Yeah. There were a lot of changes that went into effect in, was that 2021? Yeah. So, guess what? It's time to go through that process again and deal with those updates. And if you're a broker, you can't just say, oh, hey, I'm gonna get out the pen here and make some changes, right?
Please don't.
That's not gonna work, right, Damian?
Please, for the love of God, do not do that. I'll tell you guys, I don't create my own leases. I actually buy Pete's. So for any of you looking for a lease, having the guy that's got to evict on them that's always a good lease to use. So, and that's just a plug for Pete because he's actually my attorney. I've used him for several evictions over the years, but he does a great job. There's a reason that we have him teaching this class. So anyways, if you do need a lease, that might be the way to go, is to talk to Cheddar Sulzer and find out what theirs looks like and what it costs.
Thank you for the plug, Damian. I'll be sure to come back next year. So yeah, there's other stuff too, that there's other changes such as radon testing. There's changes that impact meth. I mean, if you've ever known anybody that's had to deal with a meth mitigation situation, or if you've had to deal with it yourself, you realize how expensive and how costly that can be. Tens of thousands of dollars, depending on how many units might be affected, or even if it's, just one house. And it doesn't have to be a meth cookhouse. I mean, this stuff is toxic, right? It could be somebody using meth could trigger the levels that would require a remediation. And the big change with that is, it used to be that if you did the remediation, you got everything to the appropriate levels, great. You didn't have to disclose anything. And there was a protection by statute that that's fine. You remediated, you're good. Now there's a public database that information could be available for up to 5 years. So that's just kind of one of those big changes.
I'll tell you, with the meth one, I don't know how I feel about that, because brokers always have the obligation to disclose because of the way the law was written. So maybe the landlord having to disclose that is not bad for brokers, but that's neither here nor there.
Yeah, it's one of those things to be aware of. And I guess the other thing that pops up too, if you had a meth remediation, and neighbors are gonna talk, right? People are gonna know. They're gonna be like, hey, what were those hazmat suit guys doing in there?
Big old gear with big old face masks and moon boots walking through, that just was crazy.
Yeah. I mean, it's not like that's something that's just done really subtly and really cloak and dagger type of thing. So the fact that there needs to be some sort of disclosure, it's not the worst thing, but it's also just a consequence of a change, right?
Hey, could we talk about the radon one real quick?
Yeah,
because I don't. And maybe do you talk about this later some more about the radon requirement now, or?
Yeah, we can rip up the script though. I mean, we're good.
No, go ahead. If you talk about it later, we'll talk about it then, because that's a big deal.
It is a big deal. And I think the real important thing is if you've done testing, you have to disclose that, right? And if you don't disclose that, that's going to create a problem because it's going to give the tenant an out and the ability to terminate their lease.
Yeah,
I think that's the big kicker right there.
And I'll tell you how much I love the radon lobby. They are my favorite of all times. For all of those wondering why we got contracts released in August, the reason is because the radon lobby decided to screw with our contract and put in warnings. Now, it's not as bad as it could have been, because what they wanted to put in there was essentially make it a la lead-based paint disclosures, which was have a document signed before anybody entered into a contract. Otherwise, they would turn or void the contract. But the problem is while they were able to roll that back in the sales side, landlord tenant side did not get it rolled back. You now have an obligation to have a standalone form that has to be signed by the tenant before you enter the lease, disclosing what you know about radon. Otherwise, the tenant can void the lease. And that is a big deal. And if you guys need a form, obviously, I'm sure Chair Sulzer and Pete have a form for you guys if you're buying their lease or anything else. But the Bar Association also created one just to make it available for brokers too, if you wanted to look that direction too.
Yeah, that's good information.
You're
good. No, I mean, I think that's kind of the key thing. I mean, the other thing is radon's an interesting, somewhat controversial topic anyway, right? I mean, you can go to some parts of the country, Montana, and go to a radon spa where people go in to get exposed to radon. Now, is that a good idea? Is that not a good idea? I don't know. I'm not a doctor, but
are you serious? I didn't know that.
Yeah, no, it's a real thing. Yeah,
awesome.
It's craziness. Yeah.
Well, and the way you mitigate radon is you open a window. I mean, I'm sorry, I'm oversimplifying. There's been people that have gotten sick for it, so I don't mean to make light of it. But nonetheless, it does seem that radon, as far as its health consequences, is a little different than asbestos or meth that you just talked about, or formaldehyde, or some of these others that don't have nearly the protections that radon just got.
Yeah. And, it's a good point too. We talk about these things. People have different reactions to different things, right? Like if you took a cat into this room, watch out. I would not be I would not be doing well, right? Because I'm very allergic to cats. But so people are impacted differently. And I think it's just important to recognize that, look, there's different perspectives on dealing with these things. But the laws have come out that say, hey, we have to deal with them this particular way here in the state of Colorado. So we got to deal with them and you need to be aware of them. So the other thing that we'll talk about too is the warranty of habitability. There were some changes there that enhanced protections in the event that there is an environmental public health event. There are also some additional tweaks that could create some more challenges and more complications if you're dealing with a warranty of habitability issue and you happen to be dealing with an eviction issue too. So we'll talk about that a little bit more too. All right. So before we get off to that legislation, let's talk about the CARES Act, right? I mean, as if there wasn't enough going on, the CARES Act, for those of you who are not familiar with that passed during the initial COVID wave at the federal level, and it offered protections related to various things, from dealing with foreclosures to dealing with evictions. And the impact on evictions was if your property was a CARES covered property, or the unit CARES covered, because you could have the property if it had a federally backed mortgage, then the CARES Act would apply to that. Or if your tenant has Section 8, then it's that particular unit is a CARES covered property. Well, there was a split between the different courts as far as what type of notice and whether or not the CARES Act still applied, because the argument was that, hey, look, this was a temporary act. It was dealing with the emergency situation. It had a time period that there was a stay where you couldn't do any evictions, essentially. And the 30-day notice was really dealt with when that act expired. However, some courts said, hey, no, this act is still in place. So if you have a CARES covered property, you have to give a 30-day rent demand. Well, the Colorado Supreme Court weighed in on a case, and they basically came back and said the CARES Act is still in effect in Colorado. So that means that all covered properties within Colorado have to use a 30-day rent demand. And this is just on rent cases, right? So you wouldn't have to use a 30-day demand if somebody was having a party, right, and giving a demand for compliance. But for a rent situation, it would need to be a 30-day. And so, yeah, that's kind of a big change. And the Supreme Court looked at it and they said, well, let's take a look at this legislation. And you remember, this is thick legislation that was really put together in a difficult time period, really rushed to get put together. And the Colorado Supreme Court said, you know what, it doesn't have an expiration time period here. We hear the arguments that are made that, hey, this was a temporary thing and this should have expired, but we think this is still in effect. So it is. And that has had an impact. It's if you're dealing with a covered property, it's got to be a 30-day demand. Denver, of course, still has their renters' rights and resources package. And there's also some additional changes that we're going to talk about here in a moment related to eviction demands too.
Hey, Pete, would you reiterate what a covered property is real quick, just so everybody knows what we're talking about?
Yep, absolutely. So a covered property is a property that has a mortgage on it that's a federally backed mortgage. So think Fannie, think Freddie situation. Those properties would be considered covered. Now, it's also covered if you own your property outright, but you have a tenant in there that has a Section 8 voucher, right? Because that's a federally subsidized situation. That would also make the property covered.
Thank you.
Yep.
Hey, Pete, where can people find access to the database of meth affected properties?
So I believe that is hosted at I want to say it's the Colorado Department of Public Health and Environment. So the CDPHE, I believe they are the ones that are hosting that. And I haven't looked at it, so that's just off the top of my head. So that's my little disclaimer there. So talking about the impact on the screening process, and this bill, it was 23-184 that went into effect beginning of August, and this really impacts the screening and talking about the income requirements. So it's fairly common that a lot of people would have an income requirement that you had to make 3 times the amount of monthly rent. Now your income screening is going to vary a little bit. Again, if there's a subsidy, you can only screen the tenant's portion of the income at 200%. And that's of the tenant's portion of the income. Some people have vouchers that cover the entire rent. In that case, you're not income screening at all. The other thing to keep in mind is that if somebody has a voucher, you can't consider their credit score, period. Some people have said, well, hey, can I take a look at their credit score for determining their security deposit amount? No, you cannot. So that's a big change. Now, if you're talking about a conventional property or conventional situation where somebody's coming into you without a subsidy, your income limit is 200% of the tenant's income. You can screen somebody with their credit score for a conventional property. So there are a few other things that are related to this. If you don't do this correctly, then you could have an initial penalty of $50. And this isn't like one of those things where it's like, okay, we can get a demand letter and then it's $50. No, if you don't do it correctly, you're automatically on the hook for $50 to the tenant. And if you don't fix it, then you could be looking at $2,500 plus economic damages, plus court costs, plus attorney's fees. And why is it a big deal to have the attorney's fees in there? It's a big deal.
It's a big deal to have attorney's fees in there.
Exactly. It always is, because there's only 2 ways you can get attorney's fees in Colorado generally, right? 1, if you have them in the contract, and 2, if there's a statute that provides for them. So what do we have here? We have a statute. Why do they put that in the statute? I wonder. What are they looking for there? Oh, maybe attorneys to get involved to sue landlords. Okay. Yeah, that's probably what they're trying to do. They're trying to incentivize people to get involved in those cases, which is a common thing that most people in the industry are familiar with from security deposit disputes, right? Because in security deposit disputes, the tenant can get their attorney's fees awarded. So
somebody asked real quick, any protections for landlords with 5 or fewer units? And
not
I'm
really.
assuming we're talking about this. So
Yeah, no, there's carve outs as far as talking about 5 or fewer units when you're dealing with the affidavit situation, which we're going to talk about later. But um, that's where the 5 or fewer protection kind of comes into play. And I've got to say, with that protection, it's not really that great of a carve out, because when you're dealing with situations where you've got somebody that is managing properties professionally, you're not going to be able to typically use that. So it's really not as useful. It is useful for some people, but not very many. The few and far between. So the portable screening report, this kind of ties in with the whole screening process. That's why I've got these bundled together. This is one of these solutions that seem to be looking for a problem, right? It's basically saying that, hey, look, tenants can go out, they can get their own screening report from a vendor, from a trusted vendor, right? It can't be just, hey, this is Bob on his laptop that's giving me a screening report, and here you go.
Oh, Bob.
Yep, come on. So it's one of those things that it's just like, how did this come about? It's actually, other places around the country have something similar to this. I don't know if it's really going to have a huge impact on the screening, because I'm not sure how many tenants are going to go out and say, yeah, I want to sign up and get a screening report, because the screening report itself has to have certain information. It has to have your current income, your current employer. It has to have criminal information in it, criminal background information. And I've only seen one of these so far, and it did not comply. Right, it did not check all the boxes yet. So I have yet to see one that does. I'm sure there will be one at some point. But that aside, why are we talking about this? Because it has an impact on all advertising, because the law requires you as the landlord to advertise information about the availability of the unit and also about the law itself. So let me see here. Yep, there we go. So there's the requirements that are required to be listed in the advertising, right? And this has to go, if you're advertising online, it's got to be on your website. If you're advertising it, if you're posting it at a different company, they've got to use this if you're accepting portable screening reports. It's like, wait a minute, there's an exception here. This isn't something I have to do. There's an exception, but there's some catches to that exception. So there's a carve out to this requirement, and that is if a tenant only accepts one application at a time for a unit. Okay, that's good. And if the landlord refunds all application fees within 20 days, if either side declines to move forward with the lease. Meaning, if the tenant was declined, you'd still have to give them their application fee back. So remember, there was some changes to application fees, and there were some limitations that were put into place a few years ago that said, hey, look, this can't be a profit center, right? You can't be making money off of people applying. It's got to be, the application fee has to be reflective of your actual cost that you're going to incur. So yeah, it's kind of a big change. You kind of have a big decision to make whether or not, are you going to be advertising and dealing with this portable screening report? And by the way, if you do that, you're accepting a portable screening report, you can still run your own report, your own background check, if you get the tenant's permission. You just can't charge the tenant for that cost. So you can see right here that there's a change in the business of screening tenants and the business of being a landlord. It kind of changes your math a little bit as far as how you're getting somebody into the property. And, is there any penalties for this? Yep, very similar penalties. It's a little bit different, but there's the $50 that could be due to the tenant or the potential tenant if you violate this section. And then the tenant could give you a 7-day demand if you don't cure that. And you could have liability, $2,500 plus court costs and attorney's fees.
Attorney's fees. It's the Attorney Employment Act. Yes.
It is. It is. I mean, you just can't you can't make this stuff up, man. So, you know what? Let's talk about the pets, right? Let's talk about the dogs.
Hey, before you go to that, I got a couple here that I think let's just answer real quick, if you don't mind.
Sure. We'll put Fluffy on hold. Yeah.
Yeah, put Fluffy on hold. Waiving credit score screening in effect for anyone receiving government assistance aside from housing vouchers. Is that true? In other words, can you use the credit screening if it's not a voucher? But if they're receiving any kind of assistance, you can't use credit screening, I thought, but you know better than me.
Correct. Yeah. So if anybody has any sort of voucher, you're not going to be able to use credit screening. Period.
Okay. If you post notice for eviction, can you reject payments if they are not for the full amount due, including any late fees or charges?
Well, yes, you can. So that is one of the changes that went into effect a couple years ago was this extended statutory cure, right? It used to be you gave somebody a demand for payment, whether that was 3 days or 10 days, and then they had that time period to pay. And then if they tried to pay afterwards, most people would probably end up taking that, but maybe there were circumstances where you didn't want to take it, you didn't have to take it. Now, tenants have the right to cure the default up until the time that a judgment for possession enters against them. So that's a significantly longer period of time because after the notice expires, they could still cure. But what that question goes to is, do I have to accept a partial payment? And no, you don't. And I think that one of the things that's interesting about that change in the law is that because of this extended statutory cure period, it probably puts less of an incentive for somebody to take a partial payment unless it's a significant partial payment. So it's, most cases get resolved and get figured out and people come to some sort of a resolution. But that's one of the consequences of that law, I think, is it's more difficult to justify taking a partial payment, but you don't have to take one.
Another question is there a list of trusted screening vendors or a list of requirements for allowed screenings?
So the law does have a list of what needs to be provided in the portable screening reports. And I guess the other thing with that report too is the report isn't something where, it's the tenant saying, hey, look, landlord, I want to hand you this report, right? They have to give you access where you can verify from the vendor that that's the report. So so it's probably more of an electronic type of situation. Like I said, I have yet to see one that actually complies with the requirements in the statute that say, hey, look, this is it. I'm sure there are companies that will realize that, hey, there is a marketplace here for this. How big it is, I don't know. I mean, obviously, some of the screening companies that are already providing these services to landlords could just market themselves to tenants and then, still work to landlords. But I just haven't seen it yet.
Another question. I have tenants apply to TransUnion online and pay online. Can they still do that?
Yeah. So the screening online and how that can be done. Yes, that can be done. But remember, the tenants, you might still have to accept a screening report unless you fall within one of these exceptions. And here's the challenge, right? With some of these processes of saying, hey, well, I've got this vendor that's going to do the screening for me and you pay them. Well, if somebody comes to apply and they're like, well, I have a screening report, you're not supposed to charge them because they've got the screening report. And, especially if it's a valid screening report that actually checks all the boxes, right? Somebody comes to you and they say, well, I've got a screening report. And again, it's from Bob, right? That he just, put that together. Then I think you don't have a complete application. I don't think they actually are really fully applied at that point because it's not a complying screening report.
Another question this has come up twice. It says, what if the prospective tenant applies through Zillow and Zillow charges them the application fee or the screening fee? Is that okay?
It's kind of the same thing as the TransUnion. If you're having this application that they're applying, if they're applying through Zillow for you, they could still have, there's still this issue of you've got to be able to accept the portable report unless you're going for the exception piece of it, which is to say, I'm only accepting one applicant per unit and I'm refunding any fees within 20 days if we don't move forward with the lease agreement.
And the last one I'm going to do do landlords have to accept Section 8? I guess I'll do, and then we'll do one more, and then we'll move on to.
They do. Yeah, they do. That was another law change, recent law change a few years ago that requires landlords to accept Section 8. You're not allowed to discriminate based on source of income.
Yeah, source of income. And here's my last one. You ready for this? What states are landlord friendly?
So it's funny. I was at a conference because we were originally talking about doing this in August, but I was at a conference in Chicago, and there was a panel of attorneys. There was an attorney from Massachusetts, and they would talk about, they like, hey, well, we've got this law that protects tenants in X, Y, and Z. And then the attorney from New York would say, oh yeah, we've got something similar to that. It's it's a little bit different, but here's what happens here. And then the attorney from Texas would say, well, we don't have anything like that. So I would say,
what state were they from?
From Texas? Texas is known to be a little bit more landlord friendly than some other states.
And Missouri,
and Colorado, Colorado used to be more landlord friendly, but we've seen a lot of changes over the past few years for sure.
All right, let's go on. I'm going to answer the rest of some of these myself. So,
okay. So let's talk about the pets. This doesn't go into effect until January, but it's a hot topic. So there's a limitation now as far as pet rent. It could be $35 a month or 1.5% of the monthly rent per unit. There's also a cap on pet deposits at $300 per unit. There's some other changes to this law that impact dealing with what insurance companies. They can't make breed-based decisions. And there's also additional protections for pets during the eviction process, meaning that if there was a situation where there was a pet found at the eviction, notice would need to be provided as to the shelter that the pet was going to and that type of protection, which is interesting because most of the time when I've heard of situations involving somebody finding a pet at a unit abandoned, they're taking steps to try to get involved and to try to intervene and protect the pet. But for those people that weren't doing that, there's this additional protection. So the one thing to keep in mind with this is the original version of this bill said no pet rent and no pet fees, period. So this was a change to have something. And, you can see in the slide, it talks about per unit and it talks about deposits. The most common question that I've heard is, well, what about a non-refundable pet fee? Our position on that is we recommend that people just go with a deposit, because if you have a non-refundable pet fee, somebody could make the argument that, look, you're violating the statute because the statute only authorizes a pet deposit. Also, I think the conservative interpretation is that the pet rent is per unit and not per pet. So if you've got a couple of pets, you can't be charging $70. Just keep it per unit.
Wow. Somebody asked you, do you have to accept pets?
That's a good question. So you don't have to accept pets, but what you do have to accept is if somebody has a emotional support animal that helps assist them with a disability. And remember, a disability is something that impacts a major life activity. Then you would have to accept them, and you wouldn't be charging pet rent for that because they're accepted from that. And they're actually not treated as a pet if they're the idea of saying, hey, look, I just won't accept pets, or maybe my HOA is a non-pet community, that does not necessarily mean that you won't have to have a pet in the unit. So
Can you limit the number of pets?
you can limit the number of pets. Again, though, the emotional support animal wrinkle is a big exception that could override any sort of limitation. But there are limitations on pets. Like you can only have so many dogs, you can only have so many chickens in the city of Denver, right? And I think every municipality has some sort of limit as far as the number of animals that you could have. So that's probably a good place to look. But you could also say, look, we just want to have one pet, two pets, and we think anything more than that's going to be, too much. But remember, there is that emotional support exception potentially. And it is possible for somebody to have a pet and to have an emotional support animal. So. All right. So radon, we kind of touched on. I mean, we really, look, you've got to have the disclosures. It's got to be given before the lease is signed. And there's this termination issue. I think the other question that I've heard a lot of is, hey, look, what about existing leases? And this isn't, none of these laws are retroactive, right? They don't go back in time. So this is dealing with new law or new leases moving forward that you would have to do that disclosure. And the other thing I would say is that people say, well, what if my tenant wants to test for radon or wants a radon test? Do I have to do that? You don't necessarily have to do that, but I think there's a good practical reason why you'd want to do that is because you want to make sure that the test is done correctly and that you can deal with the results. Because if the test is done incorrectly and you get a false result, you're probably either going to have to rely upon that test or you're going to have to test yourself anyway. So why not kind of skip that whole dance and just go right to dealing with the testing yourself? And that testing should be significantly more affordable than, say, dealing with other more toxic situation. So gonna just kind of go through fairly quickly here some of these changes to the warranty of habitability. So the warranty of habitability basically has been expanded to provide more protections to tenants in the event of an environmental event, expand what is considered a retaliation by the landlord, and also give protections to additional individuals who might be more vulnerable than the rest of the population. So a lot of leases would say, hey, look, if you want to talk about a repair issue, you've got to notify me here at this particular spot. Well, the law now says, hey, look, you've got to, if you communicate with your landlord in a particular way, you can communicate with them in that way, and that's fine. That's sufficient, regardless of what the lease says, right? So if you're texting with your tenant, they could send you a text and say, hey, look, I've got an issue with my heat. Now, the reality is, I think most responsible landlords would say, hey, if you did that anyway, I would deal with that and address it because people want the property to be fixed. They want their tenant to be safe. And but this now it's just absolutely mandatory, right? It's in the statute. You also have a specific time period now to respond when there's an environmental public health event, and you also have to inform the tenant of the responsibilities in the event of an environmental public health event. And what is an environmental public health event? Think fire, think flood. There's also a catch-all of it could be something else that impacts tenants living nearby. Vulnerable population could be children, people with asthma, people with disabilities, people who are pregnant, or have some other condition that's not listed there that makes them more susceptible, and that is in effect. So the retaliation issues. First you've got to say, okay, what's the eligibility for a retaliation? Well, somebody has to have made a good faith complaint to the landlord or to a government agency. So it could be they just went down and complained to the code people that, hey, look, there's an issue here with the life, health, or safety, right? Or they were organizing or becoming a part of a tenants association or some other similar organization. So if they're in this sort of eligible status, you're prohibited from doing certain things like just changing the rent, right? Or eliminating services to that tenant, or just terminating the lease without written consent of the tenant, or as otherwise provided by law. Threatening or bringing a possession action. Okay, so you could see, or any other action that has intimidation, you could see what could happen if you have a situation where somebody's complaining about something. If you fixed it, and then they had some other breach, they might come back and say, hey, you're retaliating against me because you had this issue over here. You can be like, no, I'm not retaliating against you. I'm giving you this demand because you're not abiding by the terms of the lease. But you can see now that argument here, that the retaliation is part of the motivation, comes into play. What does that do? That creates more complications for the eviction process potentially, and just could kind of make things a little bit more difficult. So there are other changes. You're like, wait, when's this going to stop, man? It just keeps going on and on, right? So there's a bunch of prohibited clauses in leases, and I've got a bunch of slides here. I'm going to go through those fairly quickly, but there's all sorts of changes that are required in rental agreements. So these are in effect as of 8/7. So if you haven't had your lease updated, you're going to need to get it updated, right? Because there's all these changes in these clauses. And there's just a huge procedural change too, as far as dealing with lease break situations. There's just a lot. So let's take a quick look. Markups. So if you had a vendor come out and do a service, you're limited as to how much you can mark up that service to the tenant. So that could be 2% of the amount that the landlord was billed, or a fee not to exceed $10. You can't have both of those. It's just one or the other, and it could be up to $10. So you could have a fee to the tenant of $5, but not both. So this is basically impacting landlords as far as how they might make a profit. And it's probably more of an impact on somebody who's managing properties, multiple properties, versus somebody that's just dealing with one property. But it's still a limitation as far as how you can profit. There's a limitation on notice fees. So by notice fees, I'm talking about fees that might be charged for a failure to give notice before the end of your lease. If your lease had a requirement that, hey, you got to give me 30 days notice, and if you don't give me 30 days notice, I'm going to charge you X. Well, you can't do that anymore. You're limited to the actual damages that you incur as a landlord from the tenant's failure to give notice. And those damages might surround, hey, what's the timing that you have to get the property re-rented, and what those actual losses look like. Kind of makes things a little bit more complicated if you're going to deal with those types of fees. So there's a prohibition that prohibits from including a penalty stemming from an eviction notice, right? So this could mean, say, well, what if somebody's has a fee related to the posting of the eviction notice? Well, arguably that could be a penalty potentially. Now, if that fee is being paid to a third party process server, well, then maybe you've got a justification for doing that. But there is certainly an argument here that that could be a problem. There's a change to the attorney fee language. So this area of the has been addressed by the legislature fairly recently, requiring prevailing party language. Well, now it's prevailing party language, but it also is following a determination by a court that the party prevailed and the fee is reasonable. So what that means is that you have to have an order from a court in order to pass along the fees that you might incur with an attorney. So their demands, eviction demands, used to have list out the attorney's fees that could be incurred when going to court. Now the recommendation is, look, just don't have those fees on the demand, and those should only be added to ledgers once there's been a determination by the court in compliance with that law. There's more to this law too. There's a prohibition on a lease from waiving the implied covenant of good faith and fair dealing. What is that, right? I think the short version of it is don't be sneaky, right? That is hey, look, it's something that you could see typically in a commercial lease. It's not something that was fairly common in residential leases, but right now, you just can't waive it. You also can't waive the right of quiet enjoyment, which is the ability for the tenant to enjoy the property for the purposes for which it was rented. right? So, you have a responsibility there. If there's something that's going wrong with the property, that's creating some noise, you've got to deal with that issue. You can't say, oh no, you waive that. You're stuck there with whatever's going on in that disruption. There's also a prohibition on waiving a right to a jury trial, with the exception of an eviction. So evictions can still have that waiver, but monetary disputes cannot have that waiver. And also, you can't waive your right to a class action, the tenant's right to a class action. So I think it's important to keep in mind one of the primary sponsors of this bill is an attorney that specializes in dealing with class actions, and also has recently been targeting landlords. So just something to be aware of. All right.
Okay, before you go on, I got a whole bunch of stuff for you.
Good, because I need a sip of water.
Good. Well, I'm going to start with support animals because, those are always fun and everybody has questions about those.
Sure.
Do they provide proof from a doctor that states it's emotional support animal?
It doesn't have to be from a doctor. We've seen all sorts of proof from therapists before. Somebody that has an awareness that somebody has a disability, that gives the opinion that there is that need. Remember, you have to have a disability, then you have to have a need, and that the emotional support animal has to assist you somehow with that disability to allow you to enjoy the property as if you didn't have the disability.
Okay. The next one is for emotional support animal. If the disability isn't obvious, can we ask what disability the ESA is supporting? I think a lot of people are abusing the ESA system and there should be required proof.
Yeah. So I do think that there's a lot of abuse that goes on. And I think that really hurts the people that have the legitimate need for the animal. And, I'm of the opinion that everybody's life is better with a dog in it. So, I think there's a lot of good things that pets, not just dogs, can bring to people. But you can't say what's your disability. That's not allowed.
Yeah, bad.
And it's a big topic too. I mean, we do classes that go on for like 3 hours just dealing with emotional support animals. So there's a lot that could be unpacked in that.
Okay. I had somebody ask about House Bill 2013-32 and saying that they thought that was exempt, that landlords with 5 or fewer units are exempt for single family units. And I guess they looked on Google or something.
On 2032?
2013-32.
I don't have that one in the list, so
I don't know what it is either, but
yeah.
I thought anyways, sorry.
There are bills that are out there that do have the 5 or fewer exception on a couple of things. So the carve out for the 5 or fewer of the bills that we're talking about certainly deals with the mediation requirements in the eviction notice requirement. So if you had 5 or fewer, you could be exempted from that. And that's 23-11-20.
Okay. And then is the markup limit on each service provided?
So yes, it is. I think you've got to be careful on how you apply that, though. You can't say, oh, hey, you fixed something in the bathroom, you fixed the toilet, and you fixed the sink, so I'm going to mark up each one of those things, right? I think it's
the
probably
HVAC
safe
out and replace the filters and service, so you get both of them.
Right. I think a more conservative, prudent approach would be saying, look, you mark it up per vendor, and if they're just doing one thing, then that's it. If they're doing multiple things, there's one markup. That would be the conservative way to interpret it. And I think the other thing to keep in mind here is that, look, this is all new, and how this gets interpreted and how it plays out, it's going to depend. Ultimately it's going to depend on what a court says, and maybe multiple courts. So there's going to be a lot of room for interpretation here. So we recommend a very conservative approach to how you interpret these things. We don't want landlords to be a target. You want to be careful, but that might not be for everybody, right? So you got to figure out what's going to be in your best interest and your best risk tolerance for dealing with these things too.
do these laws apply to vacation rentals such as Airbnbs?
Well, there's some things
It
that
depends on
certainly
whether
could
they're
apply.
doing a lease or a license, right? And that's
Yeah. There's some things that could apply to those situations, certainly.
okay. Are there common laws that we should be reminded of that are in favor of landlords? Are there any new laws that have increased or that are for the purpose of helping landlords asking for a friend?
You know, here's the thing that, and I know it's a lot of doom and gloom. When I'm giving these presentations in person, there's not a lot of smiling faces in the room. And this might be of little comfort, but it could have been a lot worse. So
Wait
these
till next
bills,
come back.
yeah, exactly. I mean, these bills have been tempered from what they were originally proposed. I mean, the pet bill originally had some stuff about some sort of an unfunded fee that was going to be the only place that landlords could go to recover damages to property from pets. The idea on the 1095 bill, as far as having juries for evictions, the costs that are incurred with dealing with jury fees and the amount of time, both the cost from the court, the court's got to get a bunch of people down to court to deal with that, and then paying attorney's fees to deal with that could have been tremendous. There's a lot of things that could have been a lot worse, and some of those bills that didn't get passed, they didn't get passed from the efforts of landlords going down and testifying, showing up at task force meetings, different organizations, including the Colorado Landlord Legislative Coalition. If you're not familiar with that, take a look at that. I'm on the advisory board of that organization, and they really work to get the voice out of landlords. The Apartment Association of Metro Denver also is a big advocate for the industry and for protecting landlords too. So if you've got some concerns about what you're hearing here and what these laws are, I think look at those organizations, get involved, and make sure that your representatives and your senators, right? Because build that relationship. Let them know what your experience is as far as a landlord and how these things are impacting you.
Yeah, I think a lot of time it's lost on the legislature as to the mom and pop landlords. They think everybody's a big corporation with deep pockets that screws over tenants. I mean, that's the perspective down there.
Yeah. And, despite, a lot of people that are coming from a very different angle on that and trying to educate people about the people that are involved in the industry of managing property and owning property, and, the good that the housing providers provide. It's so easy for somebody to get caught up on one particular narrow issue when they hear one story. And it just takes, one bad landlord or one bad situation, bad actor, or somebody that's not telling the whole story. I've certainly heard that down there and hearing some of the testimony. But yeah. Damian, I know we're talking about a little bit of time. I got a couple more slides that I could talk about, or I can talk about the questions. What do you want?
Well, let me do one more question. Can we pay Pete to write a qualification criteria for screening tenants, i.e. on what basis we can screen? A colleague said his qualifications include 3 months reserves, being able where applicant currently lives, etc.
Well, certainly we can help landlords deal with their policies on their screening. The other thing too is there's limitations on how much you can require for a security deposit, right? You can only require 2 times the amount of rent for a security deposit now. So when you get into situations with prepaid rent, that gets a little bit complicated because prepaid rent is typically a security deposit unless the lease is reflected that the rent's due all at once, right? And that has other consequences to it too. So,
all right, let's go through the rest of your slides so we can wrap this up, and then if we have time, we can do a couple more.
Okay, I am going to fly through these here for you. So the virtual appearance, basically, beginning in 2024, anybody can demand that their eviction hearing take place virtually. And that could be a big change. There's virtual appearances now. But this removes some discretion from the court in being able to set an in-person hearing versus a virtual hearing. Nothing we can really do about it. Just be aware that it could create more complications on the eviction side of things. The big change as far as dealing with eviction notices is related to 1120. And that basically requires all eviction actions have an affidavit and have an advisement that goes to the tenant about their potential right to a pre-eviction mediation. And so this law is in effect now. It was effective immediately upon the governor's signature. The purpose, again, was to protect people that received certain types of assistance. That assistance is very narrowly defined as people that receive supplemental Social Security, disability, Social Security disability insurance, and the Colorado Cash Works program, which is TANF. And those are very narrowly defined things that make up the assistance. So somebody has to receive that assistance in order to be eligible for a pre-eviction mediation. And so that mediation, if that doesn't take place, then you have to provide an affidavit saying why it didn't take place. Either the tenant didn't qualify, or you weren't aware. So there's some breakdown there that goes along with that process. There are requirements to the affidavit. Again, just kind of listed that out, right? Does the tenant not disclose that they received assistance, or did you participate in the mediation and it wasn't successful? Maybe they don't receive any assistance. Here's the 5 or fewer. That's one of the things that would be an exemption here from that requirement. And the big change here is you want to document whether or not your tenant receives assistance. You want to keep that information so that you can ask about that up front. That's okay now. That was one of the changes in this law. So you can add that to your process. There's some operational changes that are part of this. Your lease needs to be amended. You have to have a statement in your lease now that related to source of income discrimination. Again, so the eviction demand, the statutory advisement, and the assistance affidavit are now all part of the eviction process. So if the tenant does receive the assistance, there's another delay on the back end of the eviction. So if you don't get it resolved at the mediation, you go to the eviction, that doesn't, you get a judgment for possession. There's now a stay after that of 30 days. So basically, this is almost a 2-month delay on the eviction process if somebody is receiving assistance. The mediation, there's a specific place you want to go. That's the State Office of Dispute Resolution. The mediation can't be just sitting down talking and saying, oh, hey, we're going to mediate this. You can have a mediation like that, but that doesn't qualify for this. So we recommend using this office because the scheduling is done through the state. They're set up to do that. There's a time period, a 14-day time period by which they have to sort of make that available. If that's not available, you could potentially skip the mediation. The cost, at one point it was listed at $30 an hour, but now it's $50 an hour. Your lease can't require that the tenant pays for the mediation costs. So if you go through ODR, the state actually pays the tenant's fees. But it's $50 an hour, and it's a 2-hour minimum that you end up paying just to get the mediation scheduled. And most of those are done virtually. One of the things with COVID, a lot of the mediators were able to really adapt to doing a virtual mediation, which is super helpful for getting people to participate. So yeah, we hit fast forward there and got through all those. So 44 slides, Damian.
Bravo. Wow. Everybody wants to hire you, Pete. So I have to ask, what is your ideal client, and when would you suggest brokers reaching out to you for help?
Yeah, well, certainly, our ideal client is somebody that wants to, work on getting things set up the right way, right? And is willing to sort of engage in a dialogue on what they're looking for, but willing to listen to advice. I think the other thing to keep in mind too is that there's a lot going on here, right? In fact, so much so that we're talking about lease changes. we've got like a queue of people that are lined up to have their lease change dealt with and addressed. But we do have available an addendum that people can use with their existing leases to as a sort of a temporary shortcut until your actual lease gets reviewed, that amends your lease so that you're in compliance. But yeah, we do have a way on our website, which is right there. It's the thslawfirm.com if somebody's interested. And we do have, various things that are available to clients, whether or not it's, we do regular webinars where we give regular updates to clients. We do different classes related to different specific topics, whether it's fair housing or other hot issues that are going on. And we do different client luncheons too. So, yeah.
So where would people sign up for those webinars?
So they would need to be a client in order to sign up for that. So they could reach out to contact us and express interest in being a client and go through, there's a form on the website. Because there's a couple of things. Sometimes people are like, hey, look, we want to access the webinars, but we don't have an eviction we need to file right now or another need. And we have a process where people can sign up for access for that and get that.
And just as a reminder, we will be, since we recorded this, we'll be sending out that recording to anybody who registered as an attendee. So we won't be doing the slides, but you'll have the full recording, which includes the slides.
And I know there were some other questions, but we're 10 minutes overdue, Pete. So I think we're going to have to wrap it up. And anybody that has additional questions, I think I've put your information in the chat, and I hope they reach out to your office. I know that you're pretty busy, so it may not be you that they get, but there's other very capable attorneys.
Yeah, no, we've got a great team, and we do take a team approach. We all work together, and which is great. And I think it's fun to help people solve problems, right? And unfortunately, there's a lot of problems that are out there to deal with, and the legislature just keeps on giving us more things to try to work around. But I think we get better at dealing with those issues the more that we work with our clients on that. So appreciate the opportunity, Damian. Great to see you, and congratulations again. And Jennifer, nice to meet you. And yeah, it's hope people got something out of it. So thank you.
I'm sure they did.
Definitely are a popular man, Pete. Everybody says thank you and how great you are. So we appreciate your time. And Damian, as always, it's great to see you.
Good to see you.
Anybody else, if you have questions for Pete, reach out to his firm. Damian, like Damian said, he put his contact information in the chat, so I'm sure they'd be happy to help you there. Other than that, have a great day, everybody.
Thank you, guys.
See ya.
Bye. Thanks.